Michael and Minister, and I very much welcome this and well done. I think this was a welcome private member's business for tonight. And Minister, I really welcome the decision to act sensibly and compassionately and rightly with regard to disregarding HAP. It is an inappropriate inclusion and should have been always an inappropriate inclusion. So it is an important step, but I suppose it is very much within the context of the review of the entire civil legal aid system, and that needs to be done, and that in the context of the justice plan, you know, I welcome all of the 5 goals that have been set out in that, but particularly number 2, which is to improve the access to justice and to modernise the court system, because that is badly needed. There's no question, but the pathway to justice is prohibitive at times for people. In the last year, we have had cases with regard to leaving certain injustices that people felt as a result of the algorithm, and I've had a lot of parents who were unable to take any sort of action because they just couldn't afford it, and yet feel that their child was discriminated against in that. So there are instances that arrive every day where there is no opportunity to move forward because the costs of litigation, and in some, I mean, Senator Martin has referenced defamation being a particularly difficult one to initiate, and if you were waiting on legal aid for that, it would be you'd be a long wait and past the statute of limitations. In it, we've had a number of discussions here. A number of the contributions this evening have talked about fees. And I'm mindful that in a context where we're talking about setting aside HAP as being inclusive so that particularly vulnerable people can get access to justice, that the discussion, particularly by lawyers, of fees may appear to be quite a difficult one, or even, dare I say, a vulgar one. But I just want to put it in context. People in their early years of being called to the bar can go and sit for a whole day making a bail application, and at the end of the day get paid €25. So when we talk about it, we're talking about it mindful that there is a huge attrition rate out of the bar. So people go and they pay a lot of money to get through college, to equip themselves, ambitious for what that might bring to their lives and their desire to advocate on behalf of others. But that's the sort of things, you know, I took cases early on in the district court and that myself in the beginning, and you would get paid €125 and a solicitor would take their cut out of that. So, you know, I think that we need to, I just want to put that in context, lest anybody think we're talking thousands or something like that here, because we're most certainly not. And I have brought this up with Minister McEntee when it was first brought to my attention, but the remuneration of the solicitors employed within the Legal Aid Board is dealt with differently to other solicitors employed by state entities like this, the Chief State Solicitor's Office or the AG's office or whatever. If you are an experienced solicitor coming into the Legal Aid Board, you are not started, your salary doesn't start at an appropriate point in the scale. You are always started at the lowest point in the scale. Consequently, there is a large turnover of staff. Because it's just not financially viable, and as people become more experienced, but as a result, very experienced people are not attracted into going, or if they go in for a period to have the financial security that goes with being employed as such, they don't stay. And then you have a lack of continuity in the solicitors dealing with the legal aid cases, and you have, so I think that contributes to the difficulties of the situation, and in the frustration I think that clients and people in need have with the situation. So I think that needs to be borne in mind. The length of the waiting lists, I believe, is a resourcing issue, and that definitely needs to be addressed. My final point really on this would be about the areas that are not covered by legal aid, and that we need a mechanism whereby when there is a change, so if recently, for instance, there has been a decision of the Supreme Court that has changed the operation of the Workplace Relations Commission. It is going to oblige oaths, it's going to oblige cross-examination. Not everybody is represented by a trade union. And while there isn't a fees risks in the likes of the workplace relations, there is still a need to brief a solicitor in some instances because the areas of law are quite complex. You know, it's not straightforward, though it is set up to be such. And I mean, members certainly of the Law Society and the Bar Council have been saying that for a long time, that you know, there needs to be an element of legal practitioners within there. But there wouldn't be legal aid, or even if it was, the statute of limitations on any employment law matter would be well and truly behind and passed by the time any sanction would come, or that would permit the legal aid element of it. So I think that we need to have a mechanism that responds to the likes of a Supreme Court determination in a situation like that, that says, okay, the circumstances here have changed, now perhaps we need a legal aid element. So there needs to be a constant reviewing of what is included and funded so that we can appropriately ensure that the most vulnerable have access to justice, because that is, at the end of this, everybody should have an access to justice. So thank you.